In this question, the principle provides for the fundamental right to move freely throughout the territory of India under Article 19 Clause 1 of the Constitution. Now, Article 19 Clause 15 further provides that the state is not prevented from making any law imposing any reasonable restrictions on the exercise of the right to move freely throughout the territory of India in the interest of general public. That is, the state can make a law imposing reasonable restrictions. Now, the facts in the present question are: X, a law teacher in Delhi, used to go to the terrorist affected area in central India region for the purpose of spreading literacy. However, state agencies were of the view that he was actively supporting the terrorism in that area. In November 2014, X conducted 15-day literacy camp in that area and went back to Delhi. Later, in December 2014, the state made a law penalizing the movement of outsiders in that area and gave it a retrospective effect from November 2014 and started the procedure for prosecuting X. This was challenged by X in the Supreme Court as being violative of Article 19 of the Constitution of India. In this question, the answer is B. That is, X shall succeed in his action. The reason for this being is Article 19(5) provides that the state is not prevented from making any law imposing any reasonable restriction on the exercise of the right to move freely throughout the territory of India in the interest of general public. That is, this part of the principle states that by virtue of Article 19(5), the state can make a law providing reasonable restriction on the movement of a person in the interest of general public. Now, applying this to the present state of facts, which provides that in November 2014, X conducted a 15-day literacy camp in that area and went back to Delhi. That is, in November 2014, the act of X was completely legal. It did not violate any provisions. Later, in December 2014, the state all of a sudden made a law and penalized the movement of outsiders in that area. To add to it, the state also gave it a retrospective effect from November 2014 and started a procedure of prosecuting X. Therefore, the act of state was not in the interest of general public because it has made an act a crime which was not an offense at the time when it was committed. Hence, this new law which was made by the state with a retrospective effect from November 2014 and ultimately for the prosecution of X will not hold good in front of Article 19 of the Constitution of India because it is not in the interest of the general public, making B the correct answer. That is, X shall succeed in his action.